चलो स्टार्ट करते हैं। इंडियन कॉन्ट्रैक्ट एक्ट यूनिट नंबर 1। कॉन्ट्रैक्ट का मीनिंग दिया हुआ है यहाँ पे सेक्शन नंबर 2 सबसेक्शन एच में। कॉन्ट्रैक्ट मीन्स एग्रीमेंट कैपेबल ऑफ बीइंग एनफोर्सेबल बाय लॉ इस कॉल्ड कॉन्ट्रैक्ट। एग्रीमेंट की डेफिनेशन हमें दी हुई है सेक्शन नंबर 2 सबसेक्शन ई में। एवरी promise when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. Proposal, when accepted, becomes a promise. Agreement is equal to offer slash proposal plus acceptance plus consideration. Contract is equal to agreement plus enforceability by law. Difference between agreement and contract basis by ICI. Meaning, scope, legal obligation, and nature. Essentials of a valid contract. By Section 10 of Indian Contract Act 1872. First, agreement. Second, free consent. Third, competency of the parties. Fourth, lawful consideration. Fifth, legal object. Sixth, not expressly declared to be void as per Section 24 to 30 and 56 and not by Section number 10 but are considered essential. First, two parties. Second, intention to create a legal relationship. Fulfillments to offer legal formalities. Third point. Fourth point, certainty of meaning. Fifth point, possibility of performance. Not by Section 10 but are considered essential. First, two parties. Green tick. One can't contact with himself. It involves at least two parties. Bracket में offer and acceptance may be made by natural person and by other persons having legal existence. Identity of parties must be ascertainable. Case law. State of Gujarat versus Ramanlal S and Company. Second point. Parties must intend to create legal relationship. Legal obligations. Parties must intend to create legal obligations. There must be an intention on the part of the parties to create a legal relationship. Social or domestic type of agreements are not enforceable in court of law. Case law Balfour versus Balfour. Third points, other formalities to be compiled with in certain cases. A contract may be written or spoken. No difference, but in the interest of parties, the contract must be written. Certain contracts requires some other formalities have to be enforceable. Example, insurance. Certainty of meaning. Fourth point. The agreement must be certain and not vague or indefinite. Fifth point, possibility of performance of an agreement. Terms of agreement should be capable of performance. Impossible act can't be enforced. By Section 10 of Indian Contract Act 1872, offer and acceptance of an agreement. First point, every promise and every set of promises forming consideration for each other is an agreement, and a proposal when accepted becomes a promise. Second point, free consent. Two or more persons are said to consent when they agree upon the same thing in the same sense, with consensus ad idem bracket meeting of minds. Consent would be considered as a free consent if it is not caused by coercion, undue influence, fraud, misrepresentation, or mistake. Third point, capacity of parties. Capacity to contract means the legal ability of a person to enter into a valid contract. Section 11 of the specifies that every person is competent to contract who, first point A, is of the age of majority according to the law to which he is subject, and B, is of sound mind, and C, is not otherwise disqualified from contracted by any other law to which he is a subject. Qualification A. Person entering into contract must be of 18 years of age. Persons below 18 years of age are considered minor, therefore incompetent to contract. Qualification B. A person To be of sound mind, he should be in his senses so that he understands the implication of the contract at the time of entering into a contract. A lunatic, an idiot, a drunken person, or under the influence of some intoxicant is not sound mind. Qualification C. A person entering into a contract should not be disqualified by his status in entering into such contracts. Such persons are an alien enemy, foreign sovereigns, convicts, etc. They are disqualified unless they fulfill certain formalities required by law. Fourth point, consideration referred to as quid pro quo, that is something in return may consist either in some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or taken by other. Fifth point, lawful consideration and object. The consideration and object of agreement must be lawful. The section 23 states that consideration or object is not lawful if it is prohibited by law, or it is such as would defeat the provisions of law, if it is fraudulent or involves injury to the person or property of another, or court regards it as immoral or opposed to public policy. Sixth point, not expressly declared to be void. Agreement entered must not be which the law declares to be either illegal or void. An illegal agreement is an agreement expressly or impliedly prohibited by law. Types of contract, total 13 types. On the basis of validity, 5 types. Mm. First point, valid contract. Agreement which is binding and enforceable is a valid contract. It contains all the essential elements of a valid contract. Second point, void contract. Contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Thus, a void contract is one which can't be enforced by a court of law. Third point, voidable contract, green tick. Agreement which is enforceable by law at the option of one or more parties thereto, but not at the option of the other or others, is a voidable contract. Following is the situation where contract is voidable. Consent is not free under coercion, undue influence, misrepresentation, or fraud. If a person promises to do something for another, but other person prevents him from performing his promise, contract becomes voidable at the option of first person. When a party to contract promise to perform a work within a specified time could be not performed within that time, contract becomes voidable at the option of the promisee. Distinction between a void contract and a voidable contract. Red tick basis by ICI, meaning enforceability, cause, performance of contract, and rights. Fourth, illegal point. It is a contract which the law forbids to be made void of initio and can't be enforced. The court will not enforce such a contract, but also the connected contracts and illegal agreements are void, but all void agreements are not necessarily illegal. Difference between void agreement and illegal agreement. Green tick. Basis by ICI. Scope, nature of punishment, collateral agreement. Unenforceable contract. Where a contract is good in substance, but because of some technical defect, that is absence in writing, barred by limitation, etc. One or both the parties can't sue upon it. On the basis of the formation of contract, four types. Express contracts, if terms are expressed by words or in writing, it is an express contract. Second, implied contracts. Contracts it contrasts came into existence by implication, that is by action or conduct of parties or course of dealings between them. Tacit contracts. Green tick. The word tacit means silent. Tacit contracts are those that are inferred through conduct of parties without any words spoken or written. Quasi contract. Quasi contract is not an actual contract, but it resembles a contract. Law creates and enforces legal rights and obligations when no real contract exists. Such obligations are known as quasi contracts. E contracts. If contract is entered using electronic means, it is known as e-commerce contracts. On the basis of formation of a contract, four types. Executed contract, when the act is done or executed, all forbearance is brought on record. Then the contract is an executed contract. Consideration is the act or forbearance. Executory contract. In an executory contract, consideration is reciprocal promise or obligation. It is to be performed in future on hence described as executory contracts. Kinds of executory contracts are as follows: 2A. Unilateral contract. It is a one sided contract in which one party has performed his duty or obligation and other party's obligation is outstanding. 2B. Bilateral contract. It is one where the obligations or promise is outstanding on the part of both the parties. Proposal offer. Section 2, subsection A. Definition: when one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such contract or abstinence, he is said to make a proposal. Essentials of a proposal slash offer are: first point, promisor or offerer. The person making the proposal or offer, offeree, the person who to whom the offer is made. Promisee or acceptor, the person accepting the offer. Second point, for a valid offer, person making it must express his willingness to do or not to do something. Third point, willingness must be expressed with a view to obtain the assent of the other party. Fourth point, offer can be positive bracket when doing as well as negative bracket may not doing or abstinence. Classification of offer. Offer can be classified as general, special, specific, special slash specific, cross counter, standing slash open slash continuing offer. General offer. First point, green tick, made to public at large and has hence anyone can accept and do the desired act. Anyone performing the conditions of offer can be considered to have accepted it until the general offer is retracted or withdrawn. It can be accepted by anyone at any time. It is a continuing offer, as it is a continuing offer. Case law: Carlyle versus Carbolic Smokeball Company, 1893. Special slash specific offer, green tick, made to specific or an ascertained person, can be accepted only by that specified person to whom the offer has been made. Case law: Bolton versus Jones. Cross offer: when two parties exchange identical offers in ignorance of each other's offers. In ignorance of each other's offer, the offers are called cross offers. There is no binding contract in such a case because offer made by a person can't be construed as acceptance of the another's offer. Counter offer: when offeree offers modification and variations in the terms of original offer bracket में qualified acceptance, he is said to have made a counter offer. It amounts to rejection of original offer, also called as conditional acceptance. Standing or continuing or open offer: offer which is allowed to remain open for acceptance over a period of time. Essentials of a valid offer: it must be capable of creating legal relations. First point, it must be capable of creating legal relations. Offer must be such as in law is capable of being accepted and giving rise to legal relationship. If not, then it is not a valid offer in the eye of law. Social invitation accepted does not create legal relations because it is not so intended. Second point, it must be certain, definite, and not vague. If the terms are vague or indefinite, its acceptance can't create any contractual relationships. Third point, it must be communicated to the offeree. Offer to the complete must be communicated to the person to whom it is made. Otherwise, there can be no acceptance of it. Acceptance of an offer in ignorance of offer is not acceptance and does not confer any right on acceptor. Case law Lalman Shukla versus Goridat. Fourth point is it must be made with the view to obtaining the assent of the other party. Offer must be made with the view to obtaining the assent of the other party addressed and not merely with the view to disclosing the intention of making an offer. It may be conditional. Fifth point A. An offer may be made subject to any terms and conditions by the offerer. Offer should not contain a term the non-compliance of which warrants. Thus, one can't say that if acceptance is not communicated by a certain time, the offer would be considered as accepted. Is 6 point over. Seventh point, the offer may be either specific or general. Any offer can be made to either public at large or to any specific person. The offer may be expressed or implied. Ninth point, rhetoric. Offer is different from a mere statement of intention. An invitation to offer a mere communication of information, a prospectus, and advertisement. First point, a statement of intention and announcement. Second point, offer must be distinguished from an answer to a question. Case law Harvey versus Fessy 1893 AC 552. Third point, a statement of price is not an offer. Fourth point, an invitation to make an offer or do business. Tenth point, rhetoric. A statement of price is not an offer. Invitation to offer. It is only a circulation of an offer. It is an attempt to induce offers and precedes a definite offer. It is an act precedent to making an offer. Acceptance of an invitation to an offer does not result in the contract, and only an offer emerges in process of negotiation. Difference between offer and invitation to make an offer. Rhetoric basis by ICI meaning test of intention sequence and example. Following are the instances of invitation to offer but to buy or sell. A prospectus by a company to the public to subscribe for its shares, display of goods for sale in shop windows, advertising auction sales, and quotation of prices sent in reply to a query regarding price. 2 मिनट का ब्रेक